Watson versus Walker and others.
Good morning, Mr. Watson. Mr. Watson, I think you go first. Is
I
that-
have 6 cases before this court today.
And you have 10 minutes to argue.
Yes, all 6. So I would like to know which order would you like me to address them, or do you want me to determine which order to address them?
I think you can, some of the issues are overlapping so that you can, Ms. Mellon, just hold the time for 1 minute until he starts his argument, if you wouldn't mind. You can, some of the facts are for all of them, so why don't you address them in the order in which you would like to address them?
Yes.
We will try to go along with you and not interrupt you if you're going to get to another case, but if you want to say when I get to that.
Yes.
Let me just mention a couple of other things. If you watch here, it's a little hard to both answer questions and watch, but the green light will go on. When the orange light begins to flash, you have 1 minute left. So you
Yes.
don't have to worry. We'll help you get to the 10 minutes. And you don't need to use all of your 10 minutes if you don't want them, okay? Do you have any other questions?
No, when the red light comes on, you stop at that moment, or does it blink a little to let you know you're getting ready?
No, the orange is the one where you know you're getting to the end. When it begins to blink, you've gone over your time.
Okay.
That if you're in the middle of, if a justice is asking you a question, you may continue to answer that question.
Yes.
Okay? You may proceed, Mr. Watson.
As I said, I'm here for 6 cases before this court. It pertains to violation of my civil rights for the past 3.5 years by the courts of the Commonwealth and different department and agencies of the Commonwealth. I'll start with the restraining order issued out of Dorchester District Court to the defendant, Sherry Walker, and to the restraining order that was denied to me at the probate court. Throughout the relationship, as I stated in the brief, it was very emotionally, physically, and financially abused. I ended the relationship. The result of the relationship was a young child, my daughter. So I went to obtain a restraining order out of the probate court in order to protect myself because the defendant was very aggressive, and I just felt that the result would be, no matter what, even though I was attacked, I would be the one who would face criminal charges. Despite Chapter 7 of 209A, the probate court, instead of having law enforcement deliver it, they made a phone call. As I said, I've been a victim of conspiracy in the Commonwealth for the past 10 years. These last 3.5 years are merely the latest episode of what I've faced for the past decade. I will make several comments here. Unfortunately, I don't have the ability to provide physical documentation because I've been denied by the Commonwealth. I did file a motion with this court for a petition for a writ of mandamus, which I was told would be acted on today, which defeats the purpose because if I'm required to deliver evidence before the court, I can't do it on the day that I appear before the court. But a review of the restraining orders immediately before I applied for a restraining order in the probate court, immediately after, will show that all the others were delivered by the police department as required by Section 7 of 209A. However, mine was delivered by a phone call, as noted on the restraining order. They did not schedule it on the docket. I had to argue for it to be placed on the docket for that day. I appeared before Justice Lewis, and despite the fact that I had a police report documenting that I had been physically assaulted by the defendant, and I expressed concern that when we would interact, because I would see my daughter weekly, that she was physically assault me. His words verbatim were, "This is not what a restraining order is for," despite the definition of abuse by Section 1 of Chapter 209A. And the fact that the defendant never appeared for the hearing, which according to Section 4 of Chapter 209A should have automatically issued the restraining order. So on May 5th, the defendant applied for a restraining order of Dorchester District Court, which was exactly 8 days before we were scheduled for the first hearing in the probate court. In her affidavit, she claimed that I threatened to kill her and one of her children for not allowing me to see my daughter, and that for refusing to sign a letter stating as such. There are various reasons why that argument doesn't stand up, that statement doesn't stand up. First of all, we were scheduled to go in 8 days before justice. There's no reason for me to ask her to sign the letter when we're physically both going to be in front of the justice. If anything, if she said I intimidated and told her to say that, then that would make more sense. It doesn't seem very logical to ask her to sign a letter when we're going to be physically in front of the judge and the judge is going to ask her anyway. But even if this court wants to give credibility to that argument, the restraining order was issued improperly. I was scheduled to appear at Taunton District Court on May 19th. I attempted to file a notice with the Dorchester District Court for a new hearing date as well as for a change of venue because the harassment and violation of my civil rights started in Dorchester District Court and has spread throughout the system. I was denied by the clerk there. She stated
Mr. Watson, forgive me for interrupting you. I wonder if I could ask you a question.
Yes.
In the normal course, if an order is issued or a judgment entered or not entered in the trial court, like the Dorchester District Court, you have to take an appeal to the appeals court. And as I understand it, you did not take an appeal along each of the ways?
That's incorrect.
Okay.
Justice, very briefly, they had an ex parte hearing on May 19th, which I couldn't make, and I tried to get them rescheduled. I filed a motion to dismiss and vacate, nunc pro tunc, and we appeared in court on June 18th of 2003 before Justice Gailey. He refused to review my motion and extended the order a year from that date, which, again, in violation of Section 3, gave the restraining order a lifetime of 13 months instead of the normal 1 year. The clerks refused to allow me to file a notice of appeal. So in June 18th of 2004, appeared before Judge Coffey, and despite various cases I cited that there was no reason to extend the order in addition to the violation of my due process rights originally, his exact words were, I still have concerns. I filed a notice of appeal in 2004. Since 2004, I've filed several notices of appeal and requested for the docket to be forwarded and assembled to appeals court. To this date, it has not been forwarded and assembled to the appeals court. That is why I came before this court. In similar matter, that will be same situation with the proceedings of 9488, 9510, and 9511.
Are those the...
Those are in probate court.
Okay.
I filed an appeal, notice of appeal there. It took 18 months for it to get forwarded and assembled to the appeals court, and it only did that after I filed a complaint in federal court, and the justice and the clerks were served by the U.S. Marshals. I filed a notice in the probate court to ask them to forward and assemble the record. The first Justice Moriarty said it will be handled administratively in due time. I filed a motion with the appeals court and asked them to order the probate court to forward and assemble the record. They said it will be done in its due time. I asked the office of the registrar to order the clerk to forward and assemble the record. And they said it will be done in due time. It was not until they faced a federal complaint did they react. But going back to...
And what is the status of that case in the appeals?
It's ongoing. It's under review. I was able to file it with what is similar to an affidavit of indigency. That was approved. And is one of 3 cases that's going on in proceeding. But back to the restraining order. As I said, even if the justices want to give the defendant the benefit of the doubt concerning the restraining order, it was still issued improperly. I was denied my right of due process to be there for the hearing. Then they issued it. She stated after I didn't come, they left a message on my answering machine saying, if you want to come back and give us your side of the story, you can do that, which, again, is a violation of my constitutional rights. I have the right to face my accuser, and they refused to give me that. And as I said, to this date, they still have not forwarded and assembled my record. Since I'm rushing, I'll have to hurry.
What about at the extension hearings? Were you present at the extension hearings?
I've tried that at extension hearing. Each time I filed a notice of appeal and asked that it would be assembled and forwarded, they said it would be, but they did not.
No, but I mean you were present at the hearings on whether the order should be extended.
Yes.
Am I correct? And you had an opportunity to argue at that time.
Yes, I did. That was over a year later. As far as the cases 9450, 9451 concerns the actions of the Office of the District Attorney, the complaints concern criminal complaints in which the defendant has committed against me, and it goes to what has been historically a 10-year period of the district attorney's failure to prosecute anybody who victimizes me. They were required by, in on 451 to prosecute the defendant for assault and battery with a deadly weapon against me, but they refused.
Mr.
And
Watson, as a general matter, when the district attorney, whether or not a district attorney or any other prosecutor decides to prosecute or not to prosecute, that's a decision which is in the executive branch and not the judicial branch.
I'm aware of that, Judge.
Okay.
Also, I noted in my brief, I believe it's the Attorney General versus Pelletier, that if a district attorney issues a disproportionate number of nolo prosequis, that a criminal complaint can be issued. And I say that, again, the district attorneys who have repeatedly done this to me, as well as the office of the district attorney, because I'm entitled to equal protection, and that has been done for the past 10 years. I've listed several cases in which that has occurred, despite multiple witnesses. In several instances, the defendant herself was a witness for those actions. Issue of the restraining order. I believe this was part of the conspiracy against me. From day one, I was entitled to equal opportunity as a parent, and that has been denied me. The overwhelming principle of 209C is the best interest of the child, and that has not been taken into consideration. The concern is more to harass me for opposing the Commonwealth and certain discriminatory practices against males in its courtroom. In the beginning of the hearing, there were mutual complaints of drug abuse or illegal drug use, but I passed every test. However, the defendant has failed drug tests, refused to follow a drug policy. They've refused to force her to follow a drug policy, and she has a substantial DSS record, among other facts.
Thank you, Mr. Watson, and we will read your submissions to the court. Mr. Cluff, you also have 10 minutes.
Thank you. Good afternoon, Chief Justice Marshall and Your Honors. My name is Dave Cluff. I represent Ms. Walker in SJC-09450, which is the restraining order cases. At this time, Ms. Walker will rest on her brief unless there are any questions from the court.
Am I correct in understanding, Mr. Cluff, that with respect to that case, that it is pending in the appeals court? Has a notice of appeal been taken?
I am not aware of one, Your Honor.
Okay. And do you know what the current status of the case is?
The current status of the case is that after the record was closed on this appeal, the restraining order was extended again in December of 2005 for another year. So there's another hearing scheduled for December, I think 15th or 16th, 2006.
Thank you, Mr. Cluff.
Thank you.
That's it.